states very clearly that all citizens, have the right to information, subject to the provision of the Act. That means we citizens can approach. Now, what is the obligation of public authority? Means responsibility of public authority. Section 4 beautifully pointed out that public authorities should maintain and catalog the records properly. Whatever records they should maintain properly, because people may ask question. They can come and inspect. Computerize record within a reasonable time. It is available in our file only. They can't say so. They have to computerize the things. Got it? Public, administrative, or quasi-judicial decisions to the affected person. So when organization is taking any decision, they also upload the same in the website, so that everybody will come to know. Now, C class, public information officer has to be designated. Section 5 of this Act states every public authority must designate central or state PIO, State Public Information Officer or Central Public Information Officer. Now, very important, how he will get. Dear students, under section 6, it is provided that request can be made. Why? For obtaining the information. A person who desires to obtain information under this Act shall make a request in writing or through electronic means. Online facilities also available. So a person who desires to get information, what he can do, class? He or she can make a request in writing or through electronic means in English or Hindi or in the official language of the area. Got it? Official language of the area in which application is being made. So here you can make it in Tamil also. So just filing an application is enough. It should be supported by fees. It should be supported by a very small fees. Now, suppose a person is below poverty line, unable to pay the fees. That person will not get information. What do you think? Suppose a person is poor, he or she will not get information. Answer to this basic question is that fee prescribed under this Act shall be reasonable and no such fee shall be charged from the person who are below poverty line as may be determined by the appropriate government. Suppose a person is poor, okay, and the person is below of cost, information is available to such individual. Dear students, suppose you want any information, you have to provide reason why you want that information. You want from any public authority some information. Do you have to give the reason why you need the information? Reason. Any reason you have to provide? Any reason? Any reason? Come on. Answer is applicants not required to give reasons for requesting information. They don't have to give any reason. Okay, that's why people can ask freely. So applicants are not required to give reasons for requesting information. Now, disposal of request. You ask the authority by what time they will answer. Whether you have to wait for years and years or they will answer soon. Dear students, information be provided within 30 days of request. 30 days, within 30 days. Suppose you requested today, within 30 days it will be answered. Suppose the information is in connection to life or liberty, then such information will be provided within 48 hours. Got it? It's not that. So, dear students, information to be provided within 30 days of request. If information concerns life or liberty, it must be provided within 48 hours. Let's try to understand that situation with an example. Savita is a resident, okay, of resettlement colony in Delhi. Have been promised piped water lines for many years by the government. This is an example. Okay, this is just an example. But there has been no progress. As citizen of India, many a time pipeline has been promised by the government. Nothing has been done. Can she ask information about that? Answer is yes. As citizen of India, Savita can write an RTI application to that particular state Jal Board for information on whether pipeline has been sanctioned. Just it is an example. Okay. So she can write and ask whether pipeline was sanctioned. Okay. When it will be installed? Obviously, if sanctioned, then why it has not been installed? Dear students, and what will, as a public, you have the authority to ask. Dear students, here Savita is not required to mention the reason for seeking the information. She can just ask, but she is not required to provide reason. So she can ask. And the Jal Board is a public authority. That Jal Board means water board is the what it is a public authority and required to provide information within 30 days. So when you will get the information within 30 days. But dear students, if the information is relating to life or liberty, something relating to life or liberty. Suppose there is another interesting example. A poisonous snake has bitten Sarla's brother Hari. Suppose snake bitten. Now Hari need to be treated with snake antivenom. Some medicine need to be given. Within 24 hours, Sarla takes Hari to nearest hospital. And you know where she is told that they have no information about the availability of such drug. Now, what to be done? She has to wait for 30 days. Obviously, snake bite happened, then they are saying no information available. Answer to this situation is the files RTI application. In such a case, information must be provided immediately. Dear students, within 48 hours. So see the difference of disposition of request. How? In one case, 30 days, and in case of life or liberty, it has to be disposed within 48 hours. Dear students, we like to ask questions, we like to ask information, okay, but there are certain restrictions. So, government is not bound to disclose, or public authority is not bound to disclose certain informations. Section 8 of Right to Information Act deals with that. Dear students, there are certain grounds on which if we ask, they will not answer. For example, if the information is relating to national security, if it is relating to some commercial confidence and personal information, then they will not answer. Dear students, further, your request may be rejected if you request information, and if they give such information, it will lead to infringement of copyright. So, Requests can be also rejected if they would infringe on copyright. Suppose you have taken copyright and I want some specific information, so may not be given. Dear students, this Right to Information Act also talks about the constitution of Information Commission at central and state level. For example, central and state information commissions. You know, these commissions can inquire into the complaints when filed with them, as well as have the power of a civil court. Now class, I will go to section 19. It deals with the appeal process. Means, suppose you asked information, but you were given with misleading information. You asking one thing, answered other thing. Or your application is being ignored. It may happen. Okay, they asked, we will not take care of it. A person can choose to appeal when he does not receive information as per the prescribed time. Ordinary time is 30 minutes. If the matter is related to life or liberty, it is. What happens here? So, you doesn't receive the information, or the situation is like that, he is not satisfied with the decision of public information officer. Whatever information given, not satisfied. The appeal lies before the designated officer senior in rank to that public information officer. PIO will give the information. Public authority has PIO, they will give the information. You are not satisfied. You are not satisfied. You can approach to the official who is higher in rank, above that PIO. You can go and appeal. You can write that we are not satisfied with the information given to us. Dear students, if a person is not satisfied with appeal, suppose that senior officer also answered you, but again you are dissatisfied, again you are not satisfied, then where you can go? So class, if a person is not satisfied by the response at the appeal at first level, then they can file second appeal. First appeal you understood, PIO answered, not satisfied. Higher officer you apply, not satisfied. You can go to higher forum, that is satisfied. You can go to higher forum, that is second appeal, lies to Central or State Information Commission. And dear students, decision of Information Commission are basically binding and they will resolve the issue. So class, it's not like that PIOs will. It is the constitutional duty to provide. So, who can get free legal aid? Who are eligible according to Section 12 of Legal Services Authorities Act. So, now who are eligible? Point number 1. Section 12 of Legal Services Authorities Act states that free legal services are provided to any member of scheduled caste or scheduled tribe. Then a victim of trafficking in human beings or beggar, a woman or child. See categories who can apply for free legal aid. A mentally ill or disabled person, they can also eligible for free legal aid. No money they have to pay. A person under circumstances, for example, victim of mass disaster, victim of ethnic violence, victim of caste atrocities, earthquake, etc. They are also eligible. An industrial workman. So these are the category of individuals who are eligible for free legal aid. Now, Is there any income bar or income limit? Any income bar or income limit? Free legal aid. Free legal aid. Any income bar is there? Income limit 1 lakh rupees. If any person is having below that, they can approach for free legal aid. So it is from the perspective of who wants to go to any court except Supreme Court. For Supreme Court, income limit should be below 5 lakhs. Okay, so obviously whose income is below 1 lakh, so obviously that person is also eligible. Now, very vital question knocks our mind. Free legal aid service means what? Free legal aid service. Dear students, free legal aid is the provision for free legal services in any legal issue. In any legal issue. So you get free services. Okay, that includes representation by an advocate in legal proceeding. Free of cost, there is a panel of advocates. So one advocate will represent your matter. Payment of process fee, expenses of witness, and all other charges are taken care of by state. Nothing you have to pay. Then preparation of proceeding, memo of appeal, paper books, etc. taken care of by state. Drafting of legal documents, special petition, etc. Now, very prominent question. That is, can you choose a lawyer? Can you select your lawyer for getting free legal aid? Answer is yes, it is possible to avail services of lawyer of your choice under free legal services as per Regulation 7, Clause 6 of National Legal Services Authority Regulation. Yes, it is possible. The application for legal services will be scrutinized by member secretary or secretary, and choice has to be given from the panel of lawyers. It's not like that you are choosing somebody. The person should be under that panel of advocates, and such member secretary can consider the request and allow the same. Now, very prominent question. A woman, irrespective of income or financial status, eligible for free legal aid? Woman. Do you think an woman is eligible for free legal aid? Suppose she is earning, for example, her salary package is more than that income limit. Whether she is eligible for free legal aid? Woman. Irrespective of income status, whatever would be the income, whether woman is eligible? Yes or no? Woman is eligible. Answer is yes. A woman is entitled to free legal aid irrespective of her income or financial status. Whatever would be the income status, she is eligible to get free legal aid. Whether a child can apply for free legal aid? Yes, a child is also eligible for free legal aid till the age of majority. So, this has been an approach towards free legal aid. Now, the very prominent question, where should you approach? Where you go for getting this free legal aid? Where you go? Answer to this issue is, depending upon the subject matter and territorial jurisdiction of the case, an individual should approach the appropriate authorities. For example, Taluk Legal Services Committee, which in its premises of court in that taluk, or District Legal Services Authority, which is in the premises of district court or district headquarters. That means where you can go with your matter for getting free legal aid. So you can go to Taluk Legal Services Committee, you can go to District Legal Services Authority, you can go to State Legal Services Authority, or you can go to High Court Legal Services Committee, or as per the matter, you can go to Supreme Court Legal Services Committee. So, as per the requirement, you can. Now, so I want to conclude with a very important note. Today we are here for creating awareness that is sponsored by Department of Justice. Department of Justice, you know, that is under the Ministry of Law and Justice, Government of India, for executing this free legal aid. Everybody is having Play Store in their mobile. So, to execute the planning of Article 39A, free legal aid, they introduced app so that this free legal aid can become a reality. So there are certain apps like, Tele Law app, then Pro Bono Legal Service app. Okay, so these are the services provided by the department, and they are trying to making it a reality. Now, what is Tele-Law app? Tele-Law. Tele means through telephone. Who can approach? Point to be noted. Tele-Law, reaching the unreached, is an e-interface. It is a electronic interface mechanism to seek legal advice and consultation at pre-litigation stage. Seek pre-litigation. We all are having some doubts, some legal matters. So again, free legal aid can be given. Who are eligible as per section 12 of the Legal Services Authorities Act? They can approach here. So, how this happens? Let's understand it very simply. Suppose he wants legal help. So what he can do? He can either download the Tele-Law app. Tele-Law app is there. If you try the Play Store, it is there. Okay. You can download the app. Or what you can do? You can go to Common Service Center. They are available nearby. Or you can call the helpline number 14454. So 3 ways. Tele-Law. That means people can approach if they are eligible as per section 12 of the Legal Services Authorities Act. Dear students, after this what will happen? You receive one SMS. You receive appointment SMS. That yes, you can ask your question on an appointed day. What will happen? You can consult lawyer through video call or call on the scheduled date and time, or you can go to Common Service Center where they will make arrangement for you. Now, what will happen? Advocate advice, matter over. Now, if you want to take your matter to court, Tele-Law means pre-litigation stage. You do not want to go to court, just you want to understand what can be done. Dear students, there is another application, Nyaya. Bandhu means friend. Okay, again those who are eligible as per section 12, needy, come under the marginalized category, they can approach. So, Nyaya Bandhu app. So, what you have to do in Nyaya Bandhu app, actually panel of lawyers who want to give free service, they are registered. What will happen when you need a lawyer to represent your matter to court? what will happen? Your matter, you have to apply through Nyaya app. You apply. So for that, what you have to do, you have to download the app, register yourself, put up your matter in the Nyaya app. So once ministry approves this, you will get a lawyer, you will get an advocate who represent your matter in the court. And once matter is finished, the matter is over. So advocate will update a report that the case is over, case is completed. So see how Department of Justice is basically taking up these schemes. The name of the scheme is Disha. Even under this scheme, that Nyaya project has been given to us. Dear students, discussion on law or legal aspect is very wider. 1 hour or even 2 hours discussion is not enough. You know, lot to discuss. I just covered few aspects because of time constraint. We can cover that much only. So as much as possible, we try to connect you with various aspects of law. One thing I want to tell you that ignorantia juris non excusat. You can't say as a citizen of this country you don't know the law. You can't say, because as a citizen of India, we all have to know the law. Even we are assistant professors, we are teaching law, but we are also learning, understanding, because every time we are seeing some development, some new case, some new laws are coming. Hence, it's my request to you all that organize the club very well. We will, after this program, we will hand over these club documents to sir. In that, one institutional registration form is there. Okay, that institution will apply. Along with that, students registration, who voluntarily wants to be the part of this journey. And you know, this journey is not for you all. When I connected with you, I have a hope that you connect with others wherever you go. Among your classmates, among your college mates, in your neighborhood, wherever you go. You also spread awareness in connection to law. Because, you know, everybody can acquire knowledge if they have the intention to acquire. Because nowadays, everybody is having Google in their hand. You can access any information which you like, which you prefer. Okay, so with a hope, I will put end to my discussion with you all that that narrowly is an initiative of our principal sir, Dr. S. Srinivasan. He went to the ministry because the objective is to what enlighten the youth of Puducherry. So we are under that process and we need your help in this mechanism. Okay. Thank you, dear students.
Any questions?
Yeah, any questions?
ஏன்னா இப்போ ஒரிசால ஒரு எஃப்எம் காலேஜ் ஸ்டூடெண்ட் கேள்விப்பட்டிருக்கீங்களா? என்னாச்சு தெரியுமா? அந்த பொண்ணுக்கு நடந்த தொடர்ச்சியான பிரச்சனையால பப்ளிக்கா அந்த பொண்ணு தீக்குளிச்சு. ஸ்டூடெண்ட் சரியா? என்ன படிச்சு? தீக்குளிச்சு. அப்போ அங்க என்ன நடந்திருக்குது? ஒரு கம்ப்ளைண்ட் பண்ணிருக்காங்க, அதை இக்னோர் பண்றாங்க, தொடர்ச்சியா இக்னோர் பண்றாங்க. அந்த பொண்ணுக்கு கிடைக்க வேண்டிய நியாயம் கிடைக்கல, இதுக்கப்புறம் வாழவே வேஸ்ட் அப்படின்னு சொல்லி தன்னோட உரிமை மறுக்கப்படும் போது அந்த பொண்ணு எந்த இடத்துக்கு போகணும்னு கூட தெரியாம அது என்ன பண்ணிடுச்சு? சூசைட்.